Good morning, good afternoon, good evening, wherever you may be joining us from. My name is Matt Gale, and I sincerely appreciate you being on this webinar today. I'm super excited about it. I'm Vice President of Strategic Solution Alliances for Oracle, which encompasses HCM, SCM, CX, and EPM alliances, everything but ERP. And Oracle's super thrilled to be sponsoring the webinar on balancing innovation and compliance in AI-driven employment decisions. And I've done alliance work for a number of years, and I've always said the problem with strategic alliances is that they're rarely an alliance and hardly ever a strategy. But that's not the case with Oracle and HireRight. We have a long-standing partnership of more than 20 years. We've helped organizations accelerate their hiring processes and make more informed, correct hiring decisions. And together, our solutions have helped organizations worldwide simplify the background screening process, improve the candidate experience. I've been on both sides of that equation, and ensure our joint customers have the information they need to make informed, accurate, and compliant hiring decisions. So Oracle's and HireRight, we're not just partners, we're also a customer of HireRight. And that just, I think, further solidifies the nature of our partnership. And it's probably one of the few, I'll call it frictionless partnerships that I've experienced in my career. So I really enjoy working with HireRight and helping our mutual customers. So the good part, let me introduce today's speaker, Mr. Alonzo Martinez, Associate General Counsel at HireRight. Alonzo is also a trusted advisor in the organization. I knew that even before I knew Alonzo. I had heard his name. His reputation precedes him. He's a senior contributor to Forbes, has worked in, his work has been featured in a number of publications, webinars, podcasts, news outlets. Take a homework assignment after this session, look up Alonzo and read some of the stuff. It's really good, informative content. Alonzo also chairs the Advocacy Advisory Group at the Professional Background Screening Association, further demonstrating his influence within the industry. So please help me in welcoming Alonzo Martinez, who's going to help us understand a little bit more around the legal landscape when it comes to AI and employment. And then a new acronym that we all must jam into our heads, Automated Employment Decision Tools, AEDTs, and the challenges they pose. So Alonzo, I'll hand it over to you, my friend.
Thanks so much for the introduction, Matt. I really appreciate it. And HireRight is so excited to partner with Oracle to bring you today's webinar. Like Matt mentioned, this is balancing innovation and compliance in AI-driven employment decisions. And if you've attended my talks about AI in the past, this one's going to be a little bit different in that we're going to focus on the legal and regulatory aspects of AI and employment upfront. And we're going to talk about litigation. I had initially excluded that from today's talk, but there's a few things that have popped recently that I think are worth exploring. And then we're going to dive into a few use cases, their benefits and their pitfalls, particularly in scope of background checks. So we've got a pretty full agenda for you today, but I think some really exciting topics to cover. And here it is. You know, I'm a lawyer and we love disclaimers. Just a reminder, today's chat is being offered for informational purposes only. It's not considered legal or compliance advice, but I do hope that you'll take away a few talking points to raise with your teams and your legal counsel. And just because I'm not your lawyer doesn't mean that we can't be friends. Search for me on LinkedIn. As Matt mentioned, I post a lot of compliance-related content. In fact, every week I post a brief video that summarizes what's happening that week in terms of background screening or other laws or litigation that's impacting employers. So look for me on LinkedIn. Just a few housekeeping items today. This webinar is being produced for you. So if anything piques your interest, if you need clarification on any point raised, if you have a difference of opinion or you have any questions, use that Q&A icon located at the bottom of the screen. We want to make this webinar interactive, so please engage with us and ask a few questions. And if you've attended some of my other webinars, you know that they're usually a quick-paced walkthrough of many different topics. Today, we have the luxury of focusing on a single topic, AI and employment decisions. So there should be some time at the end of the webinar to field your questions. So please use that Q&A button liberally and get your questions in. And if you experience any audio or video problems, Doreen is producing today's webinar. So just hit F5 on your keyboard to refresh the presentation. Again, that's F5 to refresh anytime you experience any audio or video problems. So let's dive right in. Emerging technologies, they create a host of new legal issues for employers, but AI, and in particular the concept of machine learning, that's been around for dozens of years. But what's relatively new is what I'm calling the commercialization of generative AI. This is natural learning models and the like. Think ChatGPT, think Microsoft Copilot. And while generative AI gets all the buzz, what's first to be regulated are automated employment decision tools, or AEDTs, as Matt said. And so, what is an automated employment decision tool? Well, automated employment decision tools are tools driven by AI technology that replace or substantially assist with decision making impacting employment or the workplace. That's what we're going to focus on today, the existing legal framework and the what I'm calling the race to regulate AI, and in particular, those AI tools that assist with your decision making in the employment lifecycle. The use of artificial intelligence in the employment lifecycle is pervasive. And as AI permeates employment decision making, there are concerns with addressing bias or perceived bias imparted by algorithms. Those employment decisions made by automated employment decision tools, or AI, can affect everything from application or resume filtering to deciding who gets an interview, who gets a job offer, who gets hired, retained, promoted, and even terminated. Using technology to lighten some of your decision-making workload, it's a good thing, right? We want to leverage the technology that we have, but it doesn't come without risks. And in some cases, it also imposes additional compliance requirements on employers who choose to use AI. But algorithms, like humans, are not immune from bias, and that's what lawmakers are focusing on. A software engineer can program an algorithm to start as a neutral decision maker, but that neutrality can be unintentionally altered when the algorithm begins to learn from the data set it receives. If the training data contains unintentionally biased information or was gathered in a way that was influenced by the biases of past decision makers, that algorithm can be susceptible to adopting those biases. And while an explicit bias within a data set can present issues, it's hidden biases within the training data that can influence an algorithm's decision making, causing it to produce biased results. In reviewing and attempting to replicate the results it has previously analyzed, that algorithm runs the risk of modeling those implicit biases underlying the training data. So this means that algorithms are only as good as the programmers who create them and the training data that they're provided with. For this reason, it's really important that employers exercise caution in implementing AI and enact procedures for monitoring and scrutinizing potentially biased results. AI should not be a scary thing. It is something that we should absolutely leverage, but we should do so in a way that is mindful. Here's the compliance note for you today. In today's talk, you're going to hear me repeatedly mention the importance of auditing and monitoring your automated employment decision tools, particularly as it relates to bias. That's a very critical point that you're going to want to remember. While bias in equals bias out, curating algorithms can work to eliminate bias, but you have to understand how they work. This is a really important compliance takeaway. As a user of AI tools that help with employment decisions, it's your responsibility to understand how those tools work. So let's cover a use case. In 2018, it was widely reported that a major retailer stopped using a recruiting tool that it had spent several years developing after that algorithm began demonstrating a persistent bias against female candidates. The algorithm was trained to evaluate job applicants for technical roles. And what it did is it used training data comprising resumes submitted to the company over a 10-year period. So what do you know about the type of employee typically hired into STEM roles? Well, in light of historical gender disparities in the technology sector, the resumes the algorithm was trained with came mostly from male candidates, as men are the most common candidates to fill technical roles, although the tides are slowly turning. So what does that mean? Well, ultimately, the algorithm began disfavoring female applicants, penalizing resumes that included the word women's and penalizing graduates of 2 all-women's colleges. Women simply were not getting included in the talent pool. Although programmers attempted to salvage this tool and cure its biases, the project was ultimately scrapped when the issue couldn't be resolved. So the retailer wasted millions of dollars and many years on a tool that was never actually used by the company's recruiters to evaluate candidates. but that's a good thing. The company adhered to the first two compliance principles that we discussed. One, they audited and monitored the algorithm for bias, and two, they attempted to understand or correct it before it was put into production. So this is what I like to call a textbook example of what to do when deploying automated employment decision tools. Audit and monitor and understand and correct any biases before using them in production. In fact, the degree to which lawmakers and regulators are pursuing AI has accelerated greatly over the last few years. Like I mentioned at the start, in past AI talks, you heard me talk about the threat of regulation. Well, that threat is now recognized for better or worse, and nothing rings louder than a joint statement concerning discrimination and bias from the Consumer Financial Protection Bureau, the Department of Justice, the Equal Employment Opportunity Commission, and the FTC, the Federal Trade Commission, big regulators. The joint statement emphasizes 3 points. One, existing legal authorities apply equally to the use of automated systems and other new technologies, which means that the agencies are going to apply existing laws and regulations to AI. That is worth repeating. Existing laws, many that are decades old, will be used to regulate AI in the employment lifecycle. The joint statement also calls out ways that AI can perpetuate unlawful bias, automate unlawful discrimination, and produce other harmful outcomes. And three, it ends with the promise that the agencies intend to vigorously protect individual rights. They are going to work in concert to prosecute or to regulate the AI lifecycle in employment decisions that result in bias or clear discrimination. And that is clearly reiterated by Charlotte Burrows, the chair of the EEOC, who's quoted as saying, "We must work to ensure that these new technologies do not become a high-tech pathway to discrimination." You can see the full quote on the screen. To that end, the EEOC has established its initiative on artificial intelligence and algorithmic fairness to examine how technology is fundamentally changing the way employment decisions are made. As part of its initiative, the EEOC has released two pieces of guidance that are relevant to today's conversation. I'm going to cover that next. But first, I should mention that I've written a companion piece to this webinar that you can find in the resource section of the webinar. So again, there's a companion piece to this webinar. You can find it in the resource section of the webinar. Download that document. It contains links to all of the laws, regulations, guidance, everything that I'm covering today. So it's really a great resource for you to reference. Let me know what you think of this document when you complete the survey at the end of today's webinar. Take a look at that document, reference it as we're going through today's talk. In terms of guidance concerning the Americans with Disabilities Act, the ADA, and artificial intelligence, the EEOC outlines 3 ways in which an employer's tools may, in the EEOC's view, be found to violate the ADA. Although I should say that this list is not exhaustive, and the EEOC has put this out as examples for employers only. So first is not providing a reasonable accommodation in lieu of AI. So let's take an example. Let's say an employer is using an AI-powered test that requires the use of a keyboard or a trackpad, and an individual has limited manual dexterity. In that case, there should be an option for an oral exam if an individual is unable to use a keyboard or trackpad to interact with that AI technology. Another example, AI screens out a candidate with a disability who can perform the essential functions of the job with a reasonable accommodation. So let's say an AI screening tool analyzes voice and it screens out somebody with a speech impediment who can perform the essential functions of the job. Then there's likely a discrimination issue. So for example, let's say you have a candidate who is going to operate a piece of machinery, but you utilize an AI technology that, because of the individual's stutter or stammer, screens them out. That stutter or stammer isn't going to impact their ability to operate that machine. As a result, you need to provide an accommodation for that individual. And the third point, AI makes a disability-related inquiry or medical examination that violates the ADA's restrictions. So what can employers do to comply with the ADA when using AI decision-making tools? Here's your actionable compliance guidance from the EEOC. Well, you can consider accommodations and allow an individual to opt out of the use of artificial intelligence as necessary and appropriate. Second, you can give notice before using solutions that use AI. The EEOC tells us that employers should provide all applicants and employees undergoing an assessment by an algorithmic decision-making tool information, quote, in plain language in an accessible format regarding the traits that the algorithm is designed to assess, the method by which those traits are assessed, and the various factors or variables that might affect the individual's rating. Third, the EEOC recommends ensuring that AI and algorithmic tools only measure abilities or qualifications that are truly necessary for the job. And finally, the EEOC tells us that we must confirm vendor compliance. If your vendors use AI to make certain employment decisions, you have to make sure that they conform with the EEOC's guidance. Let's move on and talk about the EEOC's Select Issues document. The Select Issues document concerns the use of AI in employment decisions and disparate impact. So what is disparate impact? Well, disparate impact occurs when an employer uses a process to make employment selections, like choosing a candidate for hire over another, or uses a test that on its face appears to be neutral, but actually adversely or negatively affects a disproportionate number of individuals based on protected characteristics, think race, color, religion, sex, or national origin. So what guidance does the EEOC have for us? Well, first, they put us on notice that AI or other tools that make or substantially facilitate employment decisions about whether to hire, promote, or terminate someone are in scope and should be audited to ensure that they're not discriminatory. And if it's possible that an AI tool or solution imparts a disparate impact, employers have to establish that using the tool is, quote, job-related and consistent with business necessity, and that there's no less discriminatory alternative that's equally effective. Second, employers who use third-party solutions, software, or online tools, for example, to help make employment decisions, they're not shielded from liability if those third-party solutions end up disproportionately affecting someone in a protected class. Third, the 4/5 rule applies. So 4/5 is 80%, which can be used as a general benchmark for assessing disparate impact. So let's say you use an AI tool as part of your candidate selection process, and you're looking at two groups of candidates, let's say men and women. Based on the 4/5 rule, there should not be more than a 20% variance on who gets selected from the two groups. So for example, if your AI tool selects 100% of the men who apply, but only 70% of the women who apply, there's more than a 20% variance in that selection process, right? It's 30%. So that means that there could be evidence of discriminatory hiring practices in play, which you'd want to assess. But the EEOC tells us that the 4/5 rule is only a rule of thumb. It's not proof positive that there's discrimination, but it's worth evaluating. And finally, if you discover that your AI solution results in a disparate impact, you're going to need to stop using that tool or retool it so that it doesn't continue to result in a disparate impact. And that is the EEOC's guidance. If you have any questions concerning the EEOC's guidance as it relates to the ADA, the Americans with Disability Act, and AI tools, such as reasonable accommodation issues or guidance concerning disparate impact at the hands of AI, use that Q&A icon at the bottom of the screen. We're going to cover those questions at the end of the webinar. And I see that many of you are engaging with us with questions. So I thank you very much for your participation. So let's pivot now. And let's talk about local and state measures, starting with New York City. Again, all of these laws are covered in the companion document in the resources section of the webinar, so take a look at that. The city's Artificial Intelligence and Hiring Ordinance, Local Law 144, impacts employers who use automated employment decision tools. These are tools that substantially help with making automated employment decisions. That law became effective on July 5th, 2023. New York City's law prohibits employers from using automated employment decision tools, AEDTs, to screen candidates or employees unless a bias audit has first been conducted before deploying the AEDT. The law requires that employers use AEDTs, you have to undergo an annual bias audit on the AEDT conducted by an independent auditor, and you have to publish the results of that audit on your website. There's also a notice requirement. Employers have to provide notice to a candidate 10 days before you use an automated employment decision tool as part of your hiring process. So think about it. If you're using an AEDT, for example, to filter resumes, you're going to have to produce that well before 10 days, right? Because an individual is going to be interacting with your ATS far before that 10-day period. So you're probably going to want to publish this on your website or within your ATS as part of your job requisitions. Let's talk about Illinois, a law in Illinois that's far more targeted. This is landmark legislation that's been effective for a few years. It is the Illinois Artificial Intelligence Video Act. And it mandates several key positions for employers. First, it necessitates that prior notice be given to job applicants regarding the potential use of AI for analyzing video interviews and assessing their suitability for a position. Use AI with a if you use AI within video interviews in Illinois, you need to make sure that you're complying with this particular act. Applicants have to be provided with a comprehensive guide before the interview, explaining the function of the AI system and outlining the general types of characteristics it uses to evaluate candidates. You have to receive express consent from the applicant before using that AI tool for evaluation. The law also prohibits employers from disseminating a candidate's video to third parties unless those individuals possess expertise or technology necessary for evaluating the candidate's suitability for the position. Applicants also retain the right to request deletion of their video after a specified period. There's been a few recent amendments to the original legislation, and these recent amendments aim to address concerns of racial bias in AI systems, underscoring the state's commitment to equitable hiring practices. Notably, employers relying solely on AI for determining a candidate's suitability for in-person interviews, they have to furnish demographic information, submitting an annual report to the state that details the race and ethnic composition of individuals not offered in-person interviews or the position, as well as those ultimately hired. You have to see the differences between those that are getting the jobs and those that aren't getting the jobs. The law in Illinois underscores the state's proactive stance in ensuring fairness and transparency in the intersection of AI and employment practices. While it's not on the screen, I wanted to mention one additional point. Illinois also maintains a law that protects the collection and use of an individual's biometrics, and that's the Illinois Biometrics Information Privacy Act. Since video interviews using AI will often analyze a person's voice and facial characteristics, I think there's likely compliance requirements with the intersection of the Illinois Biometrics Information Privacy Act and their Artificial Intelligence Video Interview Act. So this means that if you conduct video interviews in AI in Illinois that use AI, you're going to need to provide notice and comply with both laws. Let me know if you want to dive deeper into that by using the Q&A function at the bottom of the screen. Let's pivot and talk about a few laws that have tangential or ancillary impact on employers and their use of artificial intelligence in employment decisions, starting with the Maryland Facial Recognition Technology Law. In Maryland, a facial recognition service is technology that analyzes facial features and is used for the recognition or persistent tracking of individuals in still or video images. It was initially introduced as a personal security-based law, but I think it's since evolved to be a little more encompassing. I'll talk about that in a second. So what is a facial template? Well, a facial template is the machine interpretable pattern of facial features that's extracted from one or more images of an individual by a facial recognition service. So employers that use facial recognition services that includes a facial template have to obtain a signed waiver providing the applicant's consent. In my opinion, since video interviews using AI analyze facial features, I think that Maryland's facial recognition technology law is likely in scope. So let's talk about that waiver. If you use AI video interviews, the waiver has to state the applicant's name, the date of the interview, the date that the applicant consents to the use of the facial recognition during the interview, and whether or not the applicant read and consents to this particular waiver. Highly technical, but that's what it requires. And recent revisions to California's Fair Chance Act, which delays an employer's inquiry into a candidate's criminal past and imposes various other assessment and notice requirements, likely also influences how AI is used in employment decisions for any candidates with criminal histories. Specifically, the revised Fair Chance Act expands the definition of an employer to include services that evaluate an applicant's criminal history on behalf of an employer. So, to the extent that AI assesses an individual's criminal history, that AI solution could be on the hook for compliance requirements under the Fair Chance Act. Think about that. California's Fair Chance Act requires that anytime a candidate has a criminal history, you have to conduct an individualized assessment to review its job relatedness. How can a vendor that evaluates criminal history for you do that on your behalf? They don't know your organization's risk tolerances. They don't know the specifics of the job that the candidate is being considered for. It's completely impractical, but that is the law. For what it's worth, it's consistent with recent case law in the state. Let me know if you have questions about that as we get to the end of this webinar. So as the use of AI becomes more prevalent in employment decisions, state legislatures across the United States are stepping up to regulate its development and aiming to ensure fairness, transparency, and accountability. So I've created this map to show you how different states are approaching AI legislation that impacts employers. I should mention that this legislation is a moving target, and this information is current as of Monday. I don't want to overwhelm you with all the details of each proposed measure since we're not certain that they will become law. If you're interested in the specifics, take a look at that companion doc I wrote. That's posted in the resources section of this webinar. You're going to find links to all of the bills, and you can even track their progress by clicking on any of those links. Just a few highlights. Bills in California, Illinois, New Jersey, New York, and Pennsylvania, they all require bias audits before deploying AI solutions and worker-facing notices. New Jersey is also considering numerous bills in a piecemeal fashion attempt to regulate AI, including a video interview bill that's very similar to the law in Illinois. Speaking of Illinois, Illinois has a really interesting bill on the books that would regulate predictive analysis and discrimination at the hands of AI. So in this case, that's making a character-based assessment predicated on where someone lives. So the characteristics that are built into their zip code specifically, I think that's really interesting legislation. And I love the name of the Massachusetts bill, which aims to, quote, prevent dystopian work environments. I find that almost Orwellian, isn't it? And one last update, since I created this deck, Colorado's bill passed both houses and has been forwarded to the governor for signature. Chances are very good that the governor will sign it, making Colorado a front runner for the state with the most comprehensive AI law. If signed, it'll become effective February 1st, 2026. The bill requires developers and deployers of AI technologies to perform impact assessments and issue public statements regarding the use of high-risk AI systems, of which employment-based tools would be a part of them. So I plan on writing an article to cover the nuances of the law, so be on the lookout for that. And I want to take a few minutes to talk about what's going on at the federal level, because it's quite interesting. At the federal level, a provision that would significantly disrupt the use of artificial intelligence in the workplace it's buried deep into a bipartisan federal proposal to legislate data privacy. If the American Privacy Rights Act is passed by Congress as currently proposed, employers would be required to notify applicants and workers when AI is used in workplace decisions. It would also allow workers to force employers to remove AI from the equation if they choose to opt out of its use for consequential employment decisions. There are a lot of questions, and the proposal is a long way off from becoming the law of the land. And even if it doesn't pass, in fact, there's a very slim chance that it will pass. I think that pieces of this legislation will be pulled out and be used by other state legislatures as they craft their own AI tools. But this issue bears close monitoring due to its potential to be a real game changer for employers. The AI portion of the proposal would require employers to do two things if they use AI for employment decisions. They would have to provide notice to applicants and employees that AI is being used, and they would have to give applicants and employees the opportunity to opt out of the use of AI. So the proposal applies to covered algorithms, which expressly includes the use of AI. And a covered algorithm is defined as, quote, any computational process, including ones derived from machine learning, statistics, or other data processing or artificial intelligence techniques. What does that really mean? Well, it's a very broad definition with very little specificity. So it could apply to a huge number of programs used by employers to manage workers. And if the proposal becomes law, employers are going to have to carefully assess exactly what products tools, services they use that could contain some aspect of machine learning, statistics, or other data processing that includes AI. You're not going to be able to rely on a defense that you didn't know that particular tool or solution or product included AI. That is not going to be a valid defense. So what are the types of AI uses that we're talking about? Well, it's exactly the type of AI that we're covering today. The compliance obligations would kick in when employers use AI to make or facilitate a consequential decision. The statute's definition leads us to believe that consequential decisions are decisions that could impact someone's access to or enjoyment of a job offer or some other at work issues. But the scope of consequential decisions is really debatable. They would certainly include decisions like whether an employer offers a job applicant a job or fires a worker. They would probably include things like promoting or demoting an employee. But what about AI that's used to help create a performance review or aid in job placements during restructuring or even help create a job description or a job posting? Are those consequential decisions? We don't know. What's even more concerning is the ambiguity behind whether AI is used to facilitate employment decisions. What does facilitate mean? I think that's a very ambiguous term. That use of facilitate could be interpreted really broadly. If AI that's evaluating an employee's performance recommends termination based on that worker's output, that's probably a facilitated decision, right? But what about AI tools that look at hundreds of applications and narrow them down to a few dozen for human review? Is that a facilitated decision? What about AI that matches the skills of existing employees to projects or open positions? Are those facilitated decisions? What about AI that exists but isn't readily apparent to its user? It's all very hard to say, and the statute doesn't make it clear. So let's talk about notice. What would the notice require? The statute tells us that the notice needs to provide meaningful information to the applicant or employee about how the AI tool makes or facilitates a consequential decision, including what potential outcomes may be. The form of the notice needs to be clear, conspicuous, not misleading. It needs to be provided in each language in which the business provides a product or service, and it has to be reasonably accessible and usable by individuals with disabilities. What about those opt-out requirements? Opt-outs, I think, are going to be really challenging for employers. If you use AI to make or facilitate consequential decisions, you're going to have to permit applicants or employees to opt out of the use of those AI solutions. How would you do that? What if an AI tool is designed to review a ton of data, like maybe thousands or millions of data sets for an employer, and one employee opts out of AI use? Would an employer then have to scrap the whole system, or could it feasibly come up with a way to work around that one employee and introduce human decision making in lieu of that AI solution for just that one worker? And what if opt-out rates are so high that they defeat the purpose of the AI tool that's being deployed in the first place? And if employees choose to opt out, are employers required to provide a path, an alternative path to help make that employment decision? All of these are questions that are open. So there's a lot to really digest here, and I'm sure you have questions. Let me know what you think of the American Privacy Rights Act, particularly how it applies to AI, when you complete the survey at the end of today's webinar. And keep getting your questions in using that Q&A icon. As we are right on track for today's webinar, let's pivot and talk about litigation. Like I mentioned, I was initially going to exclude this from the scope of today's talk, but I decided to throw it in as the integration of artificial intelligence into the employment decision-making process becomes increasingly prevalent. The legal landscape surrounding discrimination claims, it's really evolving. Were created well before the advent of AI, especially as it relates to employment decisions, leading to uncertainty regarding the application of those older laws in contexts involving AI decision making. You've already heard me mention that as part of their joint statement, numerous federal agencies have said that they're going to use existing laws to assess the impact of discrimination at the hands of AI. We also talked about the EEOC's guidance concerning disparate impact. And for me, that is amongst the key legal challenges in this domain. disparate impact claims which allege discriminatory outcomes resulting from ostensibly neutral policies or practices. So I want to cover a couple of cases that talk about this combination of AI technology, employment decision making, and disparate impact in particular, as well as discrimination in general. And the EEOC has been at the forefront of addressing these issues, bringing legal action to ensure compliance with federal employment laws. So let's dive into a couple of these cases, starting with the language tutor case. Some of you may have heard of this. In May 2022, the EEOC filed lawsuit against an online language tutor platform alleging violations of the Age Discrimination in Employment Act, the ADEA. The crux of the complaint was the language tutor platform's use of AI programs in its hiring process, which automatically rejected female applicants aged 55 and older and male applicants aged 60 and older. This practice led to the rejection of over 200 applicants who were otherwise qualified solely based on their age. This case did not go to trial. And in fact, I don't think many of these cases will go to trial. I think we're going to see them settled. This case was settled in August 2023, with the language tutor platform agreeing to pay $365,000 in back pay and compensatory damages to affected applicants. Additionally, language tutor committed to non-monetary measures, including adopting new anti-discrimination policies, conducting multiple anti-discrimination trainings, inviting rejected applicants to reapply, and ceasing to request birth dates during the hiring process. Quick sidebar while we're here. You might remember that several states require that employers exclude any information on the initial employment application that might allow them to ascertain an applicant's age, such as dates of attendance or graduation from school. Let me know if you have questions about that. Back to the language tutor case. The EEOC's in the language tutor case, for me, it underscores its commitment to addressing discrimination facilitated by AI technology. By pursuing legal action and securing a comprehensive settlement, I think the EEOC sends a clear message to us about the importance of ensuring fairness in AI-driven hiring practices. So what are some things that we can learn from the language tutor case? One, I think it's really important for employers to be vigilant in assessing the potential for discrimination in AI-powered hiring decisions. Settlement agreements with the EEOC often include non-monetary terms aimed at preventing future violations and promoting compliance with federal EEO laws. Third, the EEOC's Artificial Intelligence and Algorithmic Fairness Initiative reflects its increased focus on addressing technology-driven discrimination in the workplace. And one last note, what's particularly interesting to me is that the EEOC's first case concerning AI and employment decisions was brought against a Chinese company with remote workers in the US. So that demonstrates the EEOC's extraterritorial reach and its commitment to assessing discrimination against US workers at the hands of AI, even with offshore companies. I think that that's particularly interesting. Now, let's talk about a recently filed complaint against a popular ATS vendor. And to be upfront, as you probably noticed, I don't typically provide the actual names of plaintiffs or defendants, but I will note that Oracle is not the ATS provider that we're going to cover in today's case. And if you've attended my webinars, you know that I love audience engagement. So I'm going to provide you with a fact pattern and ask you to answer a question of law. So you're going to get to be the judge. So here are the facts in today's case. Now, the plaintiff is a Black man over the age of 40 with diagnosed mental health conditions. The plaintiff has claimed that the ATS provider's AI-driven screening process systematically discriminated against him and others based on race, age, and disability. The plaintiff faced a pattern of over 100 job rejections, all from employers using the ATS provider's platform. Those rejections often occurred within hours of applying. The plaintiff alleges that he was highly qualified for the roles. Little background on him: he has a bachelor's degree in finance from a respected college. He has an associate's degree in network systems administration. So on its face, the plaintiff seems to be well credentialed, right? He has degrees. We don't know how he was qualified for those positions, though. Nonetheless, the plaintiff asserts that the ATS provider's algorithms seem to consistently overlook his qualifications, raising serious concerns about bias in the hiring process. The plaintiff's initial lawsuit was dismissed for insufficient evidence, but the plaintiff remained undeterred because the scope of his case is potentially huge. So he filed an amended complaint seeking to provide additional details supporting his claims and bolstering his argument that the ATS provider, and more specifically, its algorithms functioned as employment agencies. Think about that. The ATS provider is an employment agency. That's his allegation. I think it's a really novel claim. In his amended complaint, the plaintiff alleged that the ATS provider mined data from numerous job applications to create decision-making patterns, effectively becoming a gatekeeper in the hiring process. He argued that the ATS provider's algorithms not only perpetuated discrimination, but also violated Title VII of the Civil Rights Act of 1964 and other federal laws designed to protect against discrimination based on race, age, and disability. So that is our fact pattern. And here is our poll. You be the judge. Could the ATS provider be considered an employment agency? Were its actions akin to that of an employment agency, which would make it liable for discrimination? I'm going to give you a few seconds to get your answers in. Choose yes or no. You have a 50-50 chance to get this right. So a few more seconds and we'll show the results. There's no wrong answer here. Come on, folks, let's get a little more engagement here. We only have around 18% of you submitting answers. Once we get to the 50% mark, I will move over. We have 35% of you. All right, a few more folks, and I'm going to give you the answer to the question. All right, everyone, thank you so much for participating. Let's see what folks have to say. All right, the majority of you think that the ATS provider could be considered an employment agency. Interesting. Well, a little bit of a trick question because the case is still pending. But what's particularly interesting to me, at least, is that the EEOC has dipped its toes in the water. The EEOC, recognizing the significance of the plaintiff's claim and its broader implication for combating discrimination in AI-driven hiring practices, they filed an amicus brief in support of the plaintiff's amended complaint, viewed that the ATS provider's algorithms met the criteria of an employment agency under Title VII, thereby subjecting it to federal anti-discrimination laws. The EEOC also asserts that the ATS provider, that their algorithms functioned as indirect employers and agents of the companies utilizing their software, which expands the scope of entities subject to federal anti-discrimination laws. This is a huge step in the EEOC's ongoing efforts to address discrimination facilitated by AI technology in the workplace. The plaintiff alleges that employers delegate their HR functions to the ATS provider, but I think realistically, most employers probably don't defer that much responsibility to the ATS provider, right? At the end of the day, a recruiter or a hiring manager is probably the person making the employment-related decisions, not the ATS provider. But the EEOC draws on an interesting analogy. The EEOC points to an IRS rule that states that tax preparation software can be considered a tax preparer if the software does more than just provide, quote, mere mechanical assistance. That's really interesting. So along those lines, the EEOC believes that an ATS provider can be akin to an employment agency. I think it's going to be interesting to see if the court buys into that argument. In the interim, the case against the ATS vendor highlights the drive towards greater scrutiny and accountability in AI-driven hiring practices to prevent discrimination based on race, age, and disability. I've said it before, but employers are going to have to remain vigilant in assessing the potential for bias in AI-driven hiring systems, and you're going to have to take proactive measures to mitigate discrimination risks to ensure compliance with federal EEO laws. So that is today's litigation update. Thanks for playing along and getting your questions in. I love this audience engagement portion. I hope you enjoyed it as well. I'm really interested in learning what you think of this case. Let me know in the survey at the end of the webinar. Let's keep it moving. With the ATS provider case, we talked about the plaintiff's belief that the class is potentially huge, and that's true because of commonality. Just think about it. In terms of the claims against the ATS provider, any non-white individual over the age of 40 whose application has been screened and kicked out by the ATS provider is a potential member of the class. So to effectively counter such arguments concerning commonality, employers need to have an in-depth understanding of how their algorithms work and be able to establish, for example, that these issues of commonality, that they don't persist across the class, that each potential plaintiff is unique. By understanding the factors the algorithm used in evaluating each member of the proposed class and demonstrating that each individual was evaluated based on their own individual qualifications, an employer can improve its ability to challenge class certification. So it'll be interesting to see what happens with this case against the ATS provider. So let's take the guidance, the regulations, the laws that we've discussed and put them all into practical application. I come from the background check space, right? We know that artificial intelligence transforms the way we perceive, conduct, and benefit from background checks. There are opportunities to unleash speed, precision, and innovation with AI decision-making and employment. But what does that look like? Well, let's go through some use cases. And I should mention that this is the way the background check industry is broaching AI and not necessarily indicative of what HireRight is doing. The industry is very interested in AI tools that provide scoring or predictive analysis. And this is ultimately what employers want. When I speak to clients, something that's often brought up is that they're inundated with this good factual data about their workers, but they don't know how to synthesize it. And that's where scoring and predictive analysis comes along. For example, there are tools that can review an individual's criminal history and determine a recidivism rate, a likelihood that they will reoffend or commit future crimes. Similarly, there are AI tools that can look at an individual's credit history and assess percentages of unsecured debt, mortgages, student loans, medical bills, and score the risk brought by an individual's credit history, and other tools that can look at public record sources to try and explain gaps in an individual's history. Now, while there are certainly benefits to scoring and predictive analysis, there are also pitfalls. Let's talk about predictive analysis as it relates to criminal recidivism, for example. It's been used by the criminal justice system for years to help judges assess an individual's eligibility for bail. But numerous reports, including a recent article by the Connecticut Law Review, have found that the AI models used to assess recidivism are by and large incorrect and notoriously flawed. In fact, the AI models used to assess recidivism were twice as often wrong about Black criminal offenders than they are for white offenders. Remember what I said early on, bias in equals bias out when it comes to AI data models. And beyond that, there's this belief that scoring is impartial. So it's easy to disassociate the human implications from a machine-born decision. And that is where we run into problems. From a compliance perspective, let's start with the EEOC. Remember that you'll need to assess if predictive analysis or scoring causes a disparate impact. Sticking with regulators from an FTC or CFPB perspective, you'll need to create a mechanism for individuals to notify the individuals of the potentially adverse information and dispute those findings. Looking at local and state measures, in New York City, there are notice and bias audit requirements. And in California, the State's Fair Chance Act would likely put the AI vendor on the hook for any discriminatory actions that result from the AI tool. So my take is that as much as we want to look at scoring and predictive analysis in terms of speeding up and innovating the background check process, we're probably not quite there yet. Let's take a different approach to integrating AI into the background check process. The Fair Credit Reporting Act regulates the process of assembling and compiling background reports. It imposes a duty of accuracy on companies that undertake the task of producing a background report. Matching a public record to an individual is a nuanced process. You can't rely on a name match only. There needs to be multiple identifiers that are considered in order to report a public record. But AI tools can be used to scour multiple sets of data to find personal identifiers and then match those identifiers to an individual. AI tools can look at the mugshots or other publicly available pictures and compare those to the candidate to source both matches and other derogatory information. There's also the potential to verify identity through AI tools that conduct photo comparisons. And in terms of using geographic information to match AI tools can look at an individual's supplied address history, their credit header, and any other information found in public records, including arrest records, to pinpoint an individual's location at the time a purported crime occurred. All of these solutions driven by AI can help to improve speed and accuracy of the background check process. And speaking of accuracy, there is much in the way of innovation towards enhancing the quality of background checks. For example, report depth, especially in terms of criminal history, can be tricky. There are some jurisdictions that require employers to conduct an if-then analysis in terms of criminal history analysis. For example, some jurisdictions limit the time frame that an employer can consider an individual's criminal history, but expand it in certain conditions, such as if an individual reoffends or is in a regulated role. AI tools can assess the unique conditions of an individual's history and ensure that the proper report depth is set. In terms of adjudication analysis, AI can be used to build continuous learning models that assess past adjudication decisions and feedback from human adjudicators to enhance the ability to spot patterns and trends that influence adjudication decisions, looking at past decisions to determine future decisions. And I think one of the most valuable uses of AI in terms of background checks is to assess the information that's disputed as incorrect or incomplete by candidates. Again, the benefit is trend analysis to help improve the quality of background reports. What's likely to be disputed? What has been disputed in the past? And how could this influence future decisions and disputes? All very valuable information. While AI can be a powerful tool for automating and enhancing various aspects of the employment process, it's crucial to approach its use with caution, particularly in areas such as predictive analysis and scoring. The legal framework, including guidelines from the EEOC and state-specific laws like those in New York City and Illinois, places responsibilities on employers and AI vendors to ensure fairness and compliance. As we move forward, it's essential to strike a balance between leveraging AI for efficiency and precision in background checks, while also upholding the principles of fairness and non-discrimination. AI should be seen as a valuable resource for automating processes, but when it comes to critical employment decisions, a thoughtful and a human-centered approach remains paramount. So automate the process and not the decision. And with that, let's open it up to questions. So a lot of questions regarding how audits are conducted. In particular, I spoke a lot about bias audits in AI, and that's a really good question. So when New York City's local law 144 came out, initially came out, they told us that employers needed to conduct a bias audit prior to deploying an AI solution. The EEOC has since basically mimicked New York City's position. But the concept of an AI bias audit is really something that was foreign. Initially, when these laws came out, many firms came together to try and provide those audits. There were law firms that tried to do it, as well as specialty technical firms. Babel.ai, for example, is one of the vendors that does AI audits. What they have to do is look at the data sets that are provided and try and assess any bias from those data sets. When I was talking about that case against the ATS vendor, I think that that's going to be a really interesting audit that's conducted against the vendor. Because when we think about disparate impact occurs against individuals that are in a particular protected class, right? Race, religion, sex, for example. In terms of that ATS vendor, in theory, as part of that initial application process, they shouldn't have any protected class information, right? The ATS vendor should not know an individual's race at the time of application. So how can their output be discriminatory? It's going to take a very specialized audit process to provide certain information into that data set and look at things like common names. For example, names that might be historically considered of a particular ethnic derivation. Scour the data to see if those names could be considered of a particular ethnic derivation and see if there was any discriminatory output in particular. New York City's New York City's regulator has really good information on local law 144 and the particulars of a bias audit on their website. If you do a web search for New York City local law 144, I've also linked to it in that resources document. You'll find their FAQs and you'll find information on bias audits right there. Let's get to a few more questions. How can employers ensure third parties are not in violation with AI laws? So again, in terms of AI solutions that impart employment decisions, that's what you really need to be focusing on. So there's a little bit of a misunderstanding right now that it's any and all AI technology. And I think that where the risk really lies is those AI vendors that are helping to automate employment decisions. So substantially assisting or replacing your automated employment decisions. Those are the vendors that you're going to want to reach out to understand if they're making a decision for you or if they're substantially assisting in your decision making, what they've done in terms of AI audits. Here at HireRight, for example, we are not replicating your employment decisions. We're providing you with information, but not facilitating that employment decision. To the extent, though, that you're utilizing a technology, for example, that identifies a specific candidate for a promotion or identifies production issues and termination decisions, those types of AI vendors would certainly be in scope, and you'd want to make sure that you're undergoing an AI bias audit with them. Questions about my ending comment here on automating the process and not the decision. I think that this is really the key takeaway from today's discussion. So AI should absolutely be used for process efficiencies. So for example, like I mentioned, in terms of background checks, we can absolutely leverage AI technologies to help with things like matching. So trying to figure out whether or not a public record relates to a particular individual. A human doing that can be a very difficult and nuanced task, right? Let's say that they're looking at court records. They would have to go through an entire court index to find that publicly available information that might help make that match. AI technology, on the other hand, can comb through that data, try and find those matching criteria. And then here at HireRight, we wouldn't use the AI solution solely for the purposes of making that match. We'd have a human say, yeah, that is a match, and that public record does belong to that individual. That is exactly the description of what a process efficiency. Automating a decision would be like something like saying an individual does not meet an employer's hiring criteria and as a result should not be hired as a result of their background check results. If that happened at the hands of AI, I think that that's something that would be far more risky and something that employers shouldn't rely completely on. Again, it's all about leveraging efficiencies from AI technology, but not utilizing AI for the purposes of automated employment decisions, at least not yet, and at least not with a lot of human oversight. Questions about AI and using them for character or personality tests. That's really an interesting area of I think the law that is currently evolving and certainly use cases that are evolving. In terms of employment decisions, I think you have to understand what the ultimate outcome of those particular tools are. To the extent that they, again, make a finite decision, a final decision for you, I think that they would be in scope for many of these laws that would require bias decisions or bias audits and specific notice requirements. To the extent that they are helping you to understand the nature or characteristics of a candidate, I think that's a little bit different. Again, remember that there could be biometrics laws. The extent that an AI solution is evaluating an individual's voice, for example, or their facial templates, Illinois law as well as Maryland law would likely come into play as well. So you'd want to understand the intersection of those particular laws. So we are just about out of time. I'd really like to thank you for joining me today. As we wrap, I want to leave you with some reminders. Use AI with purpose and intention and keep evolving. As technology changes, so should you. You'll want to engage vendors and legal counsel who understand the nuances of the intersection of AI and employment. So please take 60 seconds out of your day to complete the survey at the end of the webinar. It's my report cards, and I take your feedback really seriously. Don't forget to save a copy of that companion document that I prepared for you. You can find it in the resources section of the webinar. And again, many thanks to Oracle for sponsoring today's webinar. And thanks to all of you for joining us. You should expect to receive an email with your SHRM or HRCI credit information in a few days. In the interim, look for me on LinkedIn to get more compliance-related content. And I look forward to seeing you at a future webinar. Make it a great day, everyone.